Hey there, Matt Suing, estate planning attorney with EstateLaw Partners in Madison, Wisconsin. One of the things that I've been asked and read on the internet is whether you really need to make an estate plan. Estate planning is important to ensure that your wishes are carried out. I know it's a lot to think about, and you may feel overwhelmed when thinking about who will step in and make decisions or receive your assets. Instead of letting such worries prevent you from making a plan, we're here to help you overcome those obstacles. A time may come when you need someone to handle financial decisions or talk to your medical providers. If you have not already chosen someone in a legal document, there's a power vacuum. That void can only be filled one way. The court will need to step in, and using guardianship law while you are alive and probate law upon death, the courts will take away your right to make decisions and choose the person who will make the decisions for you and receive your assets instead. Now, here are a few important jobs that you should name someone to act. Upon death, you should name a trustee or a personal representative to wind up the affairs, keep records of the money in and the money out. An agent under a financial power of attorney who's responsible for the day-to-day financial transactions and plug any holes for any assets outside of a trust. Now, if you can't communicate or make medical decisions, someone will have to do that for you. By naming an agent under a healthcare power of attorney, you decide who's making those decisions and how you want them to act. Now, for some people, choosing decision makers is easy. For others, it can be difficult due to a tense family circumstance, geography, or just a lack of living friends or family members. Now, while most clients choose family or friends, this may not always be an option. If you don't have that go-to someone, there are professionals that can be hired. Another potential roadblock is what will happen to your assets. If you do not have an estate plan prepared, the legislature created a law called the Intestacy statute that determines who will receive everything. Generally speaking, this is the next of kin depending on who happens to survive you on the family tree. If you have life insurance and don't fill out that beneficiary designation form, the proceeds are going to either be paid to the estate and therefore probate and intestacy, or to individuals based on some default order listed in the contract. The same with retirement accounts, like 401ks and IRAs. If there's no named beneficiary, that account may go through probate, which is going to cause higher taxes, and it may be distributed based on rules that you don't agree with or you would never choose yourself. Because a judge will use state default law to determine who will receive your assets, if you do nothing, there's no choice but to leave the money outright without any protections or planning for that beneficiary's needs. You need to ask yourself, are you okay with this? Do you know who the judge will appoint? And should your default heirs receive your assets with no strings attached? If you'd like to have a conversation about your estate plan, go to our website at EstateLawPartners.com and click that Get Started button. Let's make sure your wishes are carried out. Because that's what we do with estate planning. That's why everyone should have an estate plan. To plan for the things that you care about, and you get to make your own decisions.